everybody, it's me, JJ Panzer, your smart apartment advisor with the Real Management Company, welcoming you to my new YouTube live channel. Go ahead and subscribe if you want to get updates to the videos and keep in touch with us and let us know how you like what we're doing. Today we're going to start with a little bit of a video about illegal in-law units in San Francisco. We're going to talk about when they come up, when it's good to have an illegal in-law and make it a legal in-law, when it's good to eliminate an illegal in-law and pretend it never existed, when it's good to invest in more money to make an illegal in-law a legal extra unit in your building. In-law units, it's a sort of a colloquial term. The technical term for an in-law unit is an accessory dwelling unit in planning code parlance, in legal terms. It basically means that the number of units that a building was originally intended to have, somebody added an extra unit, either by splitting apart an existing unit and making it smaller, or adding living space. The most common way of adding an in-law unit to a building, adding an accessory dwelling unit to a building, is by using underutilized basement space. It's amazing how many times, especially for single family homes, but also for apartment buildings, there is underutilized space in a building where the owner is able to build out and make extra square footage, 4, 5, 6, 800 square feet, that can be used as a living space. It can be an apartment. Now, it's not typically the best apartment in the building. Sometimes it is, but almost always it's sort of deficient in some way, shape, or form. It's on the ground floor. It doesn't have a lot of light, whatever it is. But it's there, and it's able to produce some rent. It doesn't typically produce the same amount of rent as a similar sized unit on an upper floor that has more amenities or more sunlight or anything like that, but it is useful space. Single family homes have a lot of opportunity for in-law units to be created, and the basic construct of illegal units in single family homes is that a lot of times the design of a single family home is that it's got a garage on the ground floor. You drive right into the garage and park your car, and everything on the first floor above that garage level is living space. And a lot of times there's an interior stairway that goes down into the garage, and the garage itself is only really useful for 1 or 2 car spaces in the very front of the building. You could have a tandem parking space where you have to move the car that's closest to the door out before you're able to get the back car out, or you could have just extra storage space. A lot of times that was used in the back part of the garage. In the past has been used for gardening supplies and storage and workshop or office. Over the years, as single family homes became more valuable and people lived in them for a long time, people decided maybe it made sense to build out a downstairs room and to add some square footage in the downstairs. A lot of times when families own homes throughout San Francisco, they add space because the kids are becoming teenagers, and teenagers are kind of yucky, and you don't really want the teenager living and sharing a bathroom with you. So, for 25 grand, 30 grand, whatever it was, a very small investment, you could add a bathroom and an extra bedroom down in the back part behind the garage, and the teenager could come and go as they please, or they could, just be downstairs and away from the rest of the family while they're growing up and dealing with the things that teenagers deal with. Well, this brings up the point of trying to decide what you're going to do with this space. Now, a lot of times if it's just a bathroom and a bedroom, adding that square footage is not a big deal, and there's nothing illegal about adding that square footage. You get permits, you do the work to code, and adding a bathroom and a bedroom doesn't require any additional work or additional approval other than doing the work to code and submitting for your permits from the city. Now, if you decide you want to, at the time that Junior moves out and that space is no longer usable, you don't want to make it an office, you'd like to see if you can make a little bit of extra money. You can add a kitchen to it, but you can't do that without getting a permit for that. And getting a permit to add an extra unit to your single family home takes a lot of extra effort and a lot of time and a lot of money, because changing the use of the property from a single family home to a 2-unit property is much more complicated than just adding square footage to your property. Now, If you are to add the kitchen, say, without a permit and have an illegal in-law apartment, you could certainly go ahead and rent that unit to somebody, anybody, and make a little bit of extra money. The problem with that is that by definition, that in-law apartment, that extra unit that used to be Junior's bedroom, you added a kitchen, maybe you didn't even add a kitchen, maybe you just added a counter and a refrigerator and a sink. It's not technically allowable for you to rent that as a separate dwelling unit. You could rent it as a part of your home and make some money on that. You could Airbnb that space on a short-term basis, or you could Airbnb it as a hosted rental for some period of time where there's some sharing of common areas. The person who is renting that space has access to, your living space, the kitchen, the living room, things like that in your upstairs area. But if you make it a separate second unit, it has to meet all kinds of different requirements and it has to go through a variety of different permitting processes. Failure to do so could mean that a tenant, if you rent that unit illegally without getting the proper planning and building permits to do that, it could mean that at some point down the road, even after many years of successfully renting your unit, your tenant could decide that they don't like a rent increase that you gave them, or they don't like the fact that you're asking them to leave so that you can sell your home, or that you just want to not have a tenant in the downstairs anymore. You don't want to share the space with them. And the tenant can then insist that they're going to file a lawsuit unless you buy them out, pay them a sum of money to leave. And the lawsuit would basically be, because you violated the law, you rented an illegal unit to them, that all of the rent that was charged for all those years was illegal. It was not allowable to collect that rent. And as a result, then you were required to refund all the rent that they paid. Here, let's add this up, $1,800 a month times 10 years. That's a lot of money. And then there's punitive damages that go on top of that for doing something that was illegal and for possibly risking the tenant's life in the first place. So that's a really unpleasant sort of an outcome for you to have if you are just trying to make a few extra bucks renting out that extra space in your home for a few years. So I typically recommend against renting out illegal, unwarranted space as a second unit in your home. When it comes time for, let's say, you are ready to move out of your home and you're trying to decide whether you're going to rent the home or you want to sell the home. There's a couple of things to keep in mind in that circumstance. First, if you want to rent your home, that's great. The best thing to do is to merge the unwarranted space or the built with permit space that is not a second unit into the rest of the home. Find a way to design that in as a separate bedroom bathroom suite, or bedroom bathroom with a living room, or some sort of extra office, whatever it is. Merge it into the rest of the house. The reason is your single family home, doesn't matter when it's built, doesn't matter anything else, a single family home is not subject to rent control protection. So you can rent the house for $4,000 a month, and when the year is up, you can renegotiate with the tenant. Gee, I see market rents have gone up a little bit. I'd like to get $4,250 for this house. $250 is not a legal rent increase by rent control standards, but you're not bound by rent control. You can pick whatever price you want from year to year, as long as it's more or less reasonable. You're not going to simply engineer a move out by saying, gee, I want $12,000 a month in rent in order to continue to rent you this house. That would be against the law as well, or be legally dubious, definitely unethical in a lot of ways. So if you keep the house as a single family home, you've got your 2 or 3 bedrooms and your bathroom or 2 upstairs, and you've got the extra bedroom, bathroom downstairs, it's not rent controlled. If you take your 2 units, and you rent them separately to 2 different people, now you've got 2 units. Regardless of whether they're legal or not, you're stepping over the line from 1 unit, a single family home, to 2 units, makes you rent controlled in both units. At that point, you are not able to control the rents and to determine your rent from year to year. You are stuck with the rent control and the restriction of how much you can raise the rent for both units from year to year into perpetuity. You can't increase the rents for the tenants. You can't continue to keep your rents at market. And if a tenant decides to stay for a long period of time, you're going to lose out based on the fact that the rental market in San Francisco typically increases more than just the inflation, or 60% of inflation, which is the amount of rent increase that you get as allowed by the rent board. So don't step over the line from a single family home to a 2-unit property. Legalizing that second unit means that your single family home, which is a perfectly nice, perfectly reasonable, perfectly understandable asset for somebody who is looking to buy and occupy a single family home, which is typically the majority of people looking to buy single family homes are homeowners who are going to live in them, not people looking to rent them. That very understandable asset turns into a kind of a 2-unit building, and a homeowner could buy the upstairs unit and rent the down. But why would a homeowner want to do that if they weren't looking to be a landlord? You know, they might see it as an opportunity. But the fact is that the next person, and you as well, are not allowed to remove that second unit ever. That second unit, to politicians in San Francisco, has a real value as a rent-controlled unit. It has a public value to everybody else, and you are not allowed to petition to remove a rent-controlled unit from the housing stock. So that will always be a 2-unit building. Now, if you're comparing your single-family home with a legal in-law second unit to an actual duplex, your single-family home is really, with an extra unit, is nowhere near competitive with an actual duplex. Furthermore, if you are a homeowner who's looking to buy a single-family home, you're not interested in buying a single-family home with an extra unit most of the time, especially if you are required to rent that extra unit. It's going to be kind of a hard thing. People looking to buy a duplex aren't interested in buying your substandard duplex, and people looking to buy a single family home are not looking to buy your sort of single family home kind of duplex property. So under both circumstances, you're in trouble, and you're not actually ending up with an asset that is worth buying at the same price as if you kept it as a single family home. So my recommendation to a lot of people in this circumstance is to merge the units, not legalize their extra unit if they have the chance. Merge the units into the envelope of the single family home, keep it as a single family home, sell it as a single family home, or rent it as a single family home. If you are moving out of your home for temporary reasons, and temporary, I don't mean a couple of months or a year, I mean 3 to 5 years or longer, and you're thinking you definitely want to come back to San Francisco, you definitely want to live in that home, you love that home, and you have enough equity in the property that your cash flow will work, then it certainly makes sense to rent the home as a single family home and be able to keep your rents at market from year to year. Now, one of the other circumstances where I tend to see illegal in-law units, extra units built out into a basement, or units split apart where you had one big unit that got split into 2 units, is in 2 to 4 unit buildings. If you have a 2 to 4 unit building where you have extra basement space and there's been a unit built out, or there's an opportunity to build out an extra unit in the basement area of your 2 to 4 unit property, there's no reason not to go forward with that, as long as the cost of doing so is not so prohibitive that it wouldn't be a good return on your investment. The reason is your building is going to be subject to rent control one way or another. Now, if the building is built before 1979, your property is definitely subject to rent control. If it's built after 1979, your building is not usually subject to rent control, almost never subject to rent control. And so in both circumstances, adding a 3rd unit or a 4th unit, it doesn't really become a hazardous, problematic thing. It doesn't change the math on your investment in any major way, except that it gives you an opportunity to make a little bit more money. Now, you definitely want to be careful as you're adding units to your building, making sure that you have certain things taken care of. First of all, you want to make sure that the unit is safe and that the unit will bring you enough money. And if you're interested in talking about what that could be worth, definitely give me a call and I can come and consult with you on what you might expect to get for a specific in-law unit. But you want to make sure that it's going to be worth the amount of money you're going to put into it, that the unit is going to be rentable and useful and attractive enough for you, and it will be usable in the long run by somebody in a comfortable way who's going to rent it. Now, the other thing you want to be aware of is that there are requirements. You want to make sure that you have separate metering for things like gas and electric service, and unless you've legalized your unit, you're not allowed to have a separate meter for a unit that isn't permitted to be in the building. You can't just call PG&E and say, well, I've got this 2-unit building and I want a 3rd and 4th meter for my building. PG&E says, you're not allowed to do that. A lot of times, the way people get around this limitation is that they'll have a unit for an electric meter for one unit, electric meter for the other unit, and they have what's called a house meter. It runs the common area lights, the garages, power for shared laundry facility, things like that, exterior lights, entry systems, things like that. So that common area meter is typically paid for by the landlord. And if you have that common meter, then you're able, sometimes people will add that in-law unit to the common area meter, and then the landlord is responsible for paying for that tenant's electricity usage. Now you can see how that would put you in a really awkward position as a landlord if all of a sudden you see that the electricity usage is spiked and you're responsible as the landlord for paying for that usage. There's no way to tie the tenant's usage to the tenant's cost of using that service because it's all wrapped up and combined with the other areas that are not the tenant's responsibility. So making sure you have the right extra meters is part of legalizing the unit, and it's a good benefit to legalizing an extra unit in a 2 to 4 unit property. Now, in-law units aren't always just units that are within the garage or the ground floor level. I have seen in-law units that were originally part of a big main floor unit, and the unit had a penthouse. And the penthouse was so large that it was able to be split off from the rest of the main floor unit, and that could be a separate unit. And in that case, your illegal unit, your in-law unit, is actually a more desirable unit than the rest of the building. Say it's a 5-bedroom, 3-bathroom unit, and you bring the main floor unit to be a 3-bedroom, 2-bath, and you turn the upstairs into a 2-bedroom, 1-bath. That might work really well. And I've seen that be possible in the past. So it's not always just building out in the garage or building out an underutilized basement space that makes an in-law unit valuable. Let's see, other topics that we could certainly talk about. I think in most circumstances, it really just makes the most sense. In single-family homes, don't legalize your in-law units. That's a trap. It's something that doesn't make a lot of financial sense in the long run. For 2 to 4 unit buildings, definitely investigate. The first thing you want to look at when you're investigating whether it makes sense to add an illegal or add a legal unit to your building is to talk to an architect, do a walkthrough, hire an architect for a consultation to discuss and make plans for how are you going to legalize. There may be irretrievable problems with your space that you can't address and that will be impossible to remedy with normal investments. For instance, if you have back of garage space and there is no free, say, utility egress, a trades entrance or something to the back of the building, and you have to actually go through the garage to get to the front door of the unit, that's typically something that, well, that's almost never allowable because you need to have a 1-hour burn rated exit from the property as one of the main ways of getting in and out of the unit. And going through the garage, if there's a fire in the garage, the tenant could be trapped in their unit. So you want to be able to look at something like that with an architect who understands the restrictions and is able to tell you right away, no, there's no way you could possibly make this an extra unit, and here are some ideas for ways to merge the space with the rest of the house to make it valuable. So that's my basic primer on in-law units in San Francisco, when it makes sense to add them, when it makes sense to combine them with the rest of the house. If you have any questions, feel free to give me a call or send me an email. You can call me at 415-821-3167. Send me an email, jj@rmcsf.com. Be happy to consult with anybody about in-law units or improving the value of your existing small and medium-sized apartment building, anytime, give me a call, send me an email. I'll be happy to talk with you. Thank you very much. I'm JJ Panzer, your Smart Apartment Advisor with the Real Management Company. Take care.